Good morning. Today, as promised, we're going to talk about master calendars. Master calendars are what you get when you're in removal proceedings. So right now, a lot of people coming across the border, or people who entered as visitors, or people who were married and maybe a problem came up, or people who had a green card and lost it through other reasons, will be put in removal proceedings. And the first thing that happens when they get put in removal proceedings is they have to go to a master calendar. So people ask me, what is a master calendar? What does that mean? Well, for you, usually it means if you have an asylum claim, you have to file your story so that you can start getting your 150 days for the work permit. If you have some other kind of application, such as cancellation, you may also want to file your application so that you can start getting time on your work permit. But typically in a master calendar, you don't do anything. All you have to do is show up and show up on time. And if you show up with your lawyer will do all the talking. So there's what's called a pleading. And you plead to the case and you admit and deny things. So those things then go towards, the judge at that time schedules what's called an individual or merit hearing. The individual and merit hearing is for the purpose of hearing your case with your witnesses and everything else. So let's talk a little bit more about master calendars. So since COVID-19, what has happened is that people who are not detained, people who aren't in jail, are not getting master calendars anymore. And the reason is because when you go to court at a master calendar, there are a lot of people there. And it's a large group of people and a large group of lawyers who are there to do their pleadings. And people feel uncomfortable with that. So currently the judge, the ACIJ, has said no hearings until June 15. So if you have a master calendar before June 15, it's not going to happen unless you're in jail. If you're released and you're waiting for your hearing, bad luck on that one, because you're going to have to wait till the judge reschedules it. However, that doesn't mean you can't work on your case. So a notice to appear, what is that? It's a document that puts you into removal proceedings. So technically, you aren't in removal proceedings until whatever agency, CIS or the asylum office or whoever puts you, or ICE puts you in removal proceedings. They give you a document that says you are a citizen of, and they ask you to plead to that document. And either you're going to be inadmissible or you're going to be removable, and they are going to then have a much faster master calendar, obviously, if you're in detention than if you're not. Sometimes people have to wait for these for a long period of time. And what the bigger problem is, people come across the border, ICE officer who issues the NTA often doesn't file it properly with the court. And that's a big problem, because if you don't get filed the NTA at the court, your lawyer can't file it for you. It has to be done from the government agency. And so lawyers will request, and sometimes this takes a long time because there's so many different people who might have processed the NTA and never filed it. So the notice to appear basically has different parts. You have to admit or deny, and then you have to concede the charge of removability, and you have to probably usually decline to go back to that country. And then you have to say what you want. So what relief are you seeking? So the lawyer and you should discuss this before you go to a master calendar, and it should be determined before you go to a master calendar what exactly is going to be your relief, because that's the most important thing. Because if you don't have any relief, the only thing you're going to be able to do is ask for voluntary departure. And that isn't going to be a lot of time. Unfortunately, it's going to be very limited. So if you do pre-hearing voluntary departure, it's 60. It's longer. It's 120. Otherwise, it's 60 days. So that's not a lot of time to get yourself together, leave the country, and probably know what you want to do. You probably are wanting to fight your case out. So before master calendar, it's very important to talk to a lawyer, see what they think about your case, see what they think about your relief, and then decide whether or not you're going to apply for certain different kinds of applications. The other thing to remember is that it can be quite a lot of time between the master calendar and the individual hearing. Sometimes, unfortunately, it can be years, and that's very upsetting to many people. That's just because the judges' dockets are so overloaded right now. So people often want earlier dates, and that's very hard to give. So the master calendar is also very important if you're applying on the, if you're looking at the clock issue, and the clock issue is what determines your work permit, especially for asylum. So if you have changed your venue, so say you were in Louisiana or you were in New Jersey, and the attorney moved your case to Maryland, say, or Virginia, the problem is that that stops the clock. So if you don't have the 150 days, your clock is going to stop till you go to the next master calendar, which means you aren't going to get that work permit for a very long time. So be aware of that. Also, the other thing to be aware of on a notice to appear is who has the burden of proof. Do you have the burden of proof, or does the government have the burden of proof? So sometimes the government has the burden of proof, and sometimes you have the burden of proof. So the government has the burden of proof to show that you're inadmissible, and you have the burden of proof on most other things. So we could go into the details of that. But if you're not sure about a charge, or if the date is wrong, don't admit the charge, deny it, and let the government prove their case. That's the general strategy. Now, one other thing that's new right now to remember is that because the judges are so backed up and so overloaded, what's happening is that the judges are asking that people don't come to master calendars if possible, and they have issued an order nationwide that says, you know, that you're going to do a written pleading. So instead of going to court and pleading the case, you're going to file it in writing. And then when you file it in writing, that means that you aren't going to have a master calendar probably then after that. You're going to go straight to the individual. So there are some disadvantages to that. And the disadvantage is the lawyer doesn't get to pick the date because you don't know when the individual is going to be. It could be in a year from now. It could be 6 months from now. It could be 5 years from now. So if the judge gives you a date and you already have another case that day, then you have to go ahead and reschedule. And that's a problem because they allow very limited reschedulings at this time under some case law that came out. So lots of things to consider, lots of things to remember. If you have a lawyer, you don't have to think about any of these things. It's good to ask questions, though, and to know what the questions are that you want to ask. But a good lawyer should be covering all of this and telling you what's going on so you know what's going on and you understand what's going on. So we do have some questions. So I'm going to get to these questions. So first of all, do I only get one master calendar hearing before my individual? That's a good question. So the answer is usually you're supposed to only get one master calendar, but sometimes the judge retires or the judge has got too many hours or times on his docket. So they have their own internal system. And so judges, sometimes especially Judge Crossland, he will put the case back to a master if you've asked to continue it because it's been pending too long. So then you get another master. So that, in a way, delays the case. Now, there are many reasons that sometimes lawyers do want to delay your case. If you don't have any relief, for example, they'd rather keep you here and delay the case than go forward on a case which they don't have. So that's my advice to you is just check. So can I be ordered removed at a master? Yes, you can. If you have no relief, then what happens is typically if you're eligible for voluntary departure, the attorney would have to show that you're eligible for voluntary departure by showing that you're willing and able, you have plane ticket, you're able to purchase the ticket, you have no crimes that would bar you from that or other reasons that would bar you from that. And then you would be able to take a voluntary departure. But if there is no relief at all and you're not eligible for voluntary departure, certainly at that point, the judge could order an order of removal. Or more likely what happens for orders of removal is someone doesn't show up, or they show up late. They're always going to get an order of removal. So it's so important to show up to that hearing, because if you don't show up, you're automatically ordered removed. People get confused there because they say, well, I'm not removed, I'm here. Okay, the judge's order removing you means you have a final order and the ICE can pick you up, regardless that you're in the US or not. So that's the difference. So here's another question. I have a master calendar hearing on the 6th of May. Is it still going to hold because of coronavirus? Well, the 5th of May is gone. So if you're talking about this month, it wasn't held, and it's not going to be held till they reopen in June 15. And June 15, they're going to go on their normal schedule. And then all the cases between March and June that were rescheduled are going to be administratively put back on what we call the docket, which means the judge's calendar. So that's what's going to happen. And then I think some of you are sending me very nice messages and telling me how happy you are with the work. I appreciate that very much. I'm not going to read those, but I very much appreciate that your comments and your heartfelt thanks for what you're doing. So here's another question. My court is in Baltimore, so I don't know what that question means. So it doesn't matter where your court is, if it's in Baltimore, if it's in California, if it's in Texas, it's going to be continued if it's before June 15. Now, the exception to that, as I mentioned earlier, are people who are detained. So people who are detained are going to go forward on master calendars, and they're going to go forward on individual hearings, but not those who are not detained. So for example, June 4, I have a hearing for a case that is in, the person is detained in Louisiana, the hearing is in Dallas. So if the hearing is in Dallas, the hearing's going forward, and I'm going forward with that case and have to be in Dallas on that day. So I've had, during this pandemic, unfortunately, a number of cases where I've had to travel to California and 3 times to Texas. So if you're detained, the cases go forward, and they move quite rapidly. They don't give you a lot of extra time. So any other questions from anyone? No, it looks like we don't have any more questions at this time. Let's see. Oh, it looks like we do. Okay. If you're under deportation and you appeal, and your appeal is still pending, and you get married to a U.S. citizen, will you still be deported? Well, that's a tough question. So, good question, but tough question. So if you, it depends what your case was in the first place, and if you got, what kind of finding you got, if you got a frivolous finding, or if, you know, there's a criminal issue or whatever. The fact that you're married to a U.S. citizen, and I'm going to say this twice, in no way protects you from being deported. It does not stop you being deported. It doesn't. If you read the New York Times article yesterday, it was very sad. It talked about people who have been torn from their spouses and their children, and the children left here and spouses left here because their spouse or the children, you know, lost their parent. Or so it being the fact that you are married to a U.S. citizen, and I've had people tell me, but I have U.S. citizen children, I'm fine. Not at all. They have no hesitation to arrest you if they can. And if they, and by the way, you do not get arrested at master calendars anymore. At one point, there was a point where that was happening, but that is not something that happens right now. So, and thank you to my old clients who are saying hello. I appreciate that. will the courts continue to do in-person masters post-COVID? So we just sort of answered that one, and that was the answer is they're trying not to, and I'm not sure how they're going to. They're encouraging all lawyers to file written pleadings. So I don't know how they're going to do that, because they would have to have masks available and sanitizers. And as you know, in a master calendar, people are packed into a courtroom. So I'm not sure how they're going to go about solving that problem yet. And I think they aren't either. And I think that's why they delayed the opening till June 15. So someone else says, my master calendar was shifted from April to October. Can the judge bring it closer since the courts will open June 15? Good question. But the answer is probably not, because probably that judge gave you his first date available. Because remember, just because your case was rescheduled doesn't mean he hasn't got his regular calendar full of people. So he's got to fit these people who have been rescheduled into his calendar. And some judges are better than others. I suspect you may have had Judge Crossland, because he's really quite good at rescheduling his cases very quickly. So he usually gives you his first date available. And if it's a marriage type case, you're going to get a faster date than if it's a asylum case, which, because the hearing is going to take a lot longer. And the judge wants to give you time to put on your witnesses. Other questions? How long does a master calendar last? Well, a master calendar for you lasts about 10 minutes, if that. However, sometimes you're sitting there in the courtroom waiting for your turn for the judge to call you, and there's lots of other people there, sometimes about 60 people. So that means you could be there for 2-3 hours. Master calendars typically start at 9 and go till 1 o'clock. So it means that you don't really know when you're going to get called. You get called based on the judge's calendar. I may need some water. Thank you. So the answer is, I don't know on that one. Exactly how long you're going to be there. I tell the clients, plan on being there for typically, 3-4 hours, because you don't know. And maybe don't plan to go back to work because, again, you could be going till 1 o'clock. See if we have some more questions. Apologize for that. My throat got a little tickle. My brother was in the immigration detention. He applied for asylum, but was granted removal proceedings. Okay, you can't be granted removal proceedings, but based on Ninth Circuit law, he is out of detention. Can he appeal for the asylum? Okay, I'm not sure what that question actually means. You can be released on what's called parole or parole bond. So you may mean that he was released on that. There's a Rodriguez bond in the Ninth Circuit, which is maybe what you're referring to, which allows people to get out. But if he was paroled out, that doesn't mean he was granted anything. If he was maybe granted withholding and you're asking, can he apply for asylum? You have 30 days from the judge's decision to appeal. So as long as you do it within 30 days, you can appeal that decision. Do I need to speak during the master calendar? Good question. You do need to dress nicely. Don't come out in raggedy jeans. Don't appear, to be disrespectful to the judge. But basically, the only thing the judge is going to ask you, and this, of course, does vary, because I remember a certain judge Churchill, who used to have many individuals at her master's. So she would ask all kinds of questions. That doesn't seem to happen much now with judges that I've seen lately. So typically, the only thing you're going to be asked is your name. How are you? If you're a kid, you're going to be asked maybe what school do you go to? How old are you? If you're on the juvenile docket. Otherwise, you're just going to be asked basically your address. And that's it. The lawyer should be doing all the talking. Now, if you go by yourself, and a lot of people do go by themselves at the master calendar because they don't have a lawyer or they can't afford a lawyer, usually they get continued and the judge will tell them to get a lawyer so that they are prepared next time, because people don't know how to plead. So that's the problem. If your appeal is still pending, can you renew your work permit? So if your appeal is pending at the Board of Immigration Appeals and before you had 150 days or you had a work permit before the judge ordered you removed, yes, you would be able to renew your work permit during that time. And also the good thing is it's an automatic stay, which means you aren't going to be picked up by ICE and because you've appealed. Again, a lot of very nice comments. I appreciate those as much as the questions, by the way. Thank you. If your case is scheduled in October for the master hearing, do you see it being rescheduled due to COVID? So this in my crystal ball is as good an answer that I can give you. So we don't know what's going to happen with COVID. If certainly there's a resurge or they find that people are getting infected at the courts, they may come up with a different system or they may continue cases. As of right now, they're planning to go back supposedly to normal on June 15. Now, I'm on the liaison committee for EOIR, so I get all the most recent updates, but I can't tell you till I get an email from the judge when they're going to continue it to. And usually if I did get that, we post it. And we also have a newsletter. We write a lot of this stuff in, and Monique is wonderful at doing the newsletter. She posts blogs. So you can always keep updated that way. And then we are starting to do some YouTubes, which are going to be fun. We did one last week on cancellation of removal for non-permanent residents. This coming week, next Friday, we're going to do one on, we're probably going to do two, one on cancellation removal for permanent residents. But what I wanted to talk about next week is something that I get a lot of questions on, and that's a stimulus check and unemployment benefits and how that's going to affect your green card. So that might be very important for you to know. It's new law, it's new stuff that's coming out, and a lot of people are asking me questions about that. So I'd like to talk about that next Friday. Another question. Is someone whose case is on appeal still eligible for work permit? Well, I already answered that question. So the answer is the same answer I just gave, that probably yes, based on the circumstances I gave before. And I think that is all the questions for today. So we are going to end here. And if you have more questions or you have people that you think could benefit from this, please do share this Facebook with other people. Have them sign up for the next talks. You know, we try to pick topics which clients ask a lot of questions about, which are important. And again, thank you so much for all your comments, and thank you for listening. And I hope you were able to learn a lot today. My background, as you know, is being a teacher. I taught both high school before I was a lawyer, and then I taught college. So I like people to be educated on what's going on. So that's where we are. And thank you, and I hope we'll see you again next Friday. Thank you. Bye-bye.